Welcome to StudyVix YouTube channel. Always study smart and master your future. Hello everyone and welcome back. Today we're diving into a really crucial area of Indian corporate law for this audio lecture. We're going to be focusing on Chapter XXII of the Companies Act 2013.
That's the chapter that governs foreign companies.
Exactly, the ones operating right here within our borders. And, this is, without a doubt, one of the most important and maybe one of the most challenging topics for any aspiring CA interprofessional.
It absolutely is. When we talk about foreign companies, we're really at the intersection of, global business and Indian law.
That's a good way to put it.
Our focus today will be on sections 379 right through to 393A, and we'll also be weaving in the company's registration of foreign companies rules from 2014. And this isn't just about theory for an exam.
No, not at all.
It's about really understanding the nuts and bolts of the regulatory system that makes sure these overseas companies play by our rules.
Okay, let's unpack this. I think we need a clear roadmap for our listeners. Our mission today is to really trace the journey of a foreign company from the moment it's set up overseas to the point where it becomes fully compliant here in India.
And that means identifying that key legal moment, that tipping point.
The tipping point, I like that. The moment an offshore company suddenly has to start worrying about Indian compliance.
Precisely. So we'll break it down into four main phases. First, we have what I call the inclusion test. That's section 242, which tells us who even counts as a foreign company.
Okay, so who's in and who's out.
Exactly. Second, we'll look at the enhanced applicability threshold. That's section 379. It determines just how much of the Companies Act actually applies to them.
So it's not a one-size-fits-all situation.
Not at all. Third is the compliance cycle, which is the big one, sections 380 to 386. This covers everything from registration to accounts to day-to-day operational rules.
And finally,
the enforcement mechanism, sections 392 and 393. This is where we see the real teeth of the law, the penalties for getting it wrong.
All right, that sounds like a solid plan. Let's start right at the beginning then, the definition. What exactly is a foreign company?
Well, this is where students often make their first mistake. They assume any company from outside India automatically fits the bill.
But section 242 is much more specific, right? It has those dual conditions.
Exactly, dual conditions. And they are simultaneous. So after you've established the company was incorporated outside India, you have to check for two things.
Okay, what's the first one?
Requirement 1.
Okay.
It must have a place of business in India.
And requirement 2.
It has to conduct any business activity in India in any manner. If one of those is missing, the whole of Chapter 11 just doesn't apply.
That seems clear, but I have a feeling the term place of business, or PO, is where the complexity lies. It can't just mean a physical office building anymore.
You're right, that's where the law gets really expansive. First, the POB can be established by the company itself, or, and this is very important, it can be through an agent.
Ah, so you can't just use an Indian agent to run your operations and then claim you don't have a presence here.
The law closes that loophole, and then there's the big one. The POB can be established physically, like a branch office, or it can be established through electronic mode.
The digital footprint.
Exactly. The law has caught up with technology. Physical presence is no longer the only thing that matters.
And before we get into the details of electronic mode, there's one specific type of office that Section 386 calls out, isn't there?
There is. Section 386 makes it crystal clear that a share transfer office or a share registration office, an STO or SRO, is considered a place of business.
So even if you're not selling anything in India, but you're managing your Indian investors from an office here.
You're caught. The moment that administrative office is set up, you meet the POB condition.
Okay, now let's tackle electronic mode. This has to be more than just having a company website that people in India can visit.
Oh, it's much, much broader. The rules are designed to be a dragnet. Electronic mode means carrying out electronically based activities. And the crucial part is this applies whether or not the main server is even installed in India.
So hiding your server in another country doesn't help.
Not one bit. To help you remember the scope, I use a little mnemonic. BCD Mat Karo, Data Tilakaro.
Okay, I'm intrigued. Let's break that down. What's the B?
The B is for business transactions. So B2B and B2C transactions, digital supply, things like that. Think of a company like Search and Find, Billy CD from Singapore.
Right.
If they're selling their products on an Indian e-commerce site, even with no office or employees here, they're doing business through electronic mode. They met both conditions. Of 242, they're in.
Okay, so that's B. What about D?
D is for deposits and securities. If a company is digitally offering, inviting, or accepting subscriptions in securities in India, like with IDRs, that's electronic mode. The C is not in the mnemonic, which is why it's BCD Mat Caro, but it covers financial services. Things like web-based marketing, advisory services, supply chain management done online for Indian clients.
Got it. So that leaves us with data telecaro.
Exactly. Tele is for all the online services. Telemarketing, telemedicine, distance education. Let's take Radix Healthcare from Thailand. If they offer remote health consultations to patients in India.
That's telemedicine, so it's a place of business via electronic mode.
Precisely. The law sees that economic value is being extracted from India, and it demands accountability. And data covers everything else. Email, mobile apps, social media, cloud computing. It's all in there.
That is an incredibly wide net. It feels like it could catch almost any digital interaction. Are there any specific exceptions to this?
There is one very important carve-out designed to protect our international financial services centers, the IFSCs. Under the SEZ Act, if a foreign company is just listing or offering securities electronically within an IFSC, that activity is not considered electronic mode for the purpose of this definition. It allows the IFSC to be a competitive global hub.
Right, that makes sense. Let's put this into practice with a few quick examples. Teacher mode on. Zokpak Ltd., a Japanese shipping company, opens a branch office in Mumbai.
That's the easiest case. A branch office is a classic physical POBI. Zokpak is definitely a foreign company, and the 30-day clock under Section 380 starts ticking immediately.
Okay, next one. Redstone Limited from Singapore. They hold all their board meetings in Delhi, but they have no office, no sales, no employees in India.
That's a great example. This tests the line between corporate governance and business activity. Just holding board meetings here isn't enough. They aren't conducting the operations of the company in India. So Redstone Limited is not a foreign company under this section.
What about shareholding? A company in Germany is 49% owned by an Indian company, but it has zero operational presence here.
No, it's not a foreign company. Section 242 is the gatekeeper, and it only cares about operational presence, whether physical or digital. Shareholding doesn't matter at this stage.
At this stage, that's a perfect transition, because shareholding becomes very important in the next section, Section 379.
It certainly does. Once a company is defined as a foreign company under 242, Section 379 tells us which laws apply to it.
So what's the baseline? What applies to all of them?
The baseline under Section 379(1) is that Sections 380 to 386 apply. That's the core compliance stuff, registration, accounts, service of documents. And of course, the penalty sections, 392 and 393, also apply. That's the floor.
But then we have the escalation, the 50% rule. This seems like a real game changer. Why is it there?
The thinking behind it is pretty clear. The government doesn't want companies that are effectively controlled by Indians to just incorporate overseas to sidestep the stricter rules of the Indian Companies Act.
So if the economic control is mostly Indian,
then the legal accountability should be mostly Indian too.
So how does the 50% trigger work exactly? What capital are we looking at?
We're looking at not less than 50% of the paid-up share capital. And that's broad. It includes equity, preference shares, or both combined.
And who has to hold this capital?
It could be one or more citizens of India, or it can be one or more companies incorporated in India, or, of course, any combination of those two.
And if that 50% threshold is crossed, what happens? What's the regulatory consequence?
The consequence is huge. The company now has to comply with other provisions of the Companies Act, as prescribed by the government, for its Indian business. Essentially, its Indian operations are now treated as if it were a company incorporated in India.
Wow. So that can mean a whole host of other rules suddenly apply. Things like corporate governance, board composition that aren't in Chapter 11.
Precisely. It opens the door for the Ministry of Corporate Affairs to say, okay, your Indian arm now also needs to follow rules on, say, related party transactions or board meetings, just like an Indian company. It moves them from basic compliance to advanced governance.
Let's use the Emaar Company LLC case to make this real.
It's a good idea. Emaar's from Dubai, has a POBI in India. We looked at the shareholders. Hinduja Co. Ltd., an Indian company, owns 26%. Vaishali Co. Ltd., another Indian company, owns 25%.
So the total Indian holding is 51%.
Correct. That's over the 50% threshold. Section 379(2) is triggered.
Which means Emaar isn't just filing its basic forms.
Exactly. It now has this much higher level of compliance. Its Indian business has to act like an Indian company for any provisions the government prescribes. And that is the key difference between the compliance floor and the compliance escalation of Section 379.
Okay, so once a company knows which rules apply, the clock starts ticking for that initial registration under Section 380. What's the timeline?
The timeline is very strict. It's 30 days. Within 30 days of establishing that place of business in India, all the required documents must be delivered to the registrar.
And if you miss that deadline...
You're immediately looking at the penalties under Section 392. There's no grace period.
And where do these documents actually go? This is a common point of confusion.
It is. For this initial registration, you don't go to your local ROC. Everything is centralized. You file Form FC1 with the registrar at the Central Registration Center, which is located in Gurgaon, Haryana.
And in return, you get your FCRN, your foreign company registration number?
That's right. Now, that FC1 form requires a mountain of information. The checklist is designed for total transparency.
I think we can group them into a few logical buckets, maybe parent entity identity, Indian presence, and personnel accountability.
That's a great way to structure it. For parent entity identity, you need a certified copy of its charter or memorandum and articles. And if it's not in English, you need a certified English translation.
That's non-negotiable.
Non-negotiable, plus the full address of its main office back in its home country.
And what about personnel accountability? That list of directors and the secretary?
It's exhaustive. We need everything. Name, former name, parents' names, date of birth, address, nationality, passport details, PAN number if they have one. And we also need to know all their other directorships, especially any in other Indian companies.
That cross-referencing must be key for the regulators.
It is. And this leads to another critical requirement, the authorized representative.
Right, the legal point of contact in India.
Yes. The company has to name at least one person who is resident in India and is authorized to accept legal levices on the company's behalf. This is the foundation for making sure the company can be properly served with legal documents.
And for the Indian presence bucket.
That's the full address of the principal place of business in India, plus a history of any previous business operations here. This stops companies from just disappearing and reappearing without a regulatory trace.
And finally, there are some declarations required.
Yes, the directors and the representative have to declare they haven't been convicted or debarred from managing companies anywhere in the world. And of course, you need proof of any regulatory approvals, like from the RBI, or a declaration that none were needed.
So that's the one-time registration, but things change. What happens if, say, the company moves its head office overseas?
Then Section 383 kicks in. Any alteration in the details you submitted in Form FC1 must be notified to the registrar.
And the timeline for that?
Also 30 days. Within 30 days of the alteration, you have to file Form FC2. So if Swift Pharma moves its main office from Switzerland to Singapore, they have 30 days to let the ROC know via FC2.
And what if they just pack up and leave India entirely?
If they cease to have any place of business in India, they have to notify the registrar. But the key word there is any. If they close one branch, but keep their e-commerce site running, they still have a POBI, and the compliance obligations continue.
That initial registration hurdle is a big one. But now we get into the annual recurring compliance under Section 381, the financials.
That's right. Every single calendar year, the foreign company has to prepare a balance sheet and a P&L account. But, and this is crucial, it's only for its Indian business operations.
So the regulators focus specifically on what's happening here.
Exactly. They don't need the global consolidated accounts for this filing, just the Indian part.
And these accounts need to be in a specific format.
Yes, they must be prepared as per Schedule 3 of the Companies Act, or as close to it as possible. This ensures all financial statements are comparable and meet our disclosure norms.
And I'm guessing these accounts can't just be self-certified. There's an audit requirement.
A mandatory one. The accounts for the Indian business must be audited by a practicing chartered accountant in India.
And the rules for that audit?
The rules are the same as for an Indian company. Chapter X of the Act, which covers audit and auditors, applies mutatis mutandis. So the same rules on audit appointment, duties, and removal apply.
Okay, let's talk timelines. What's the financial year, and when do these audited accounts need to be filed?
The standard financial year ends on March 31st. The deadline to deliver these documents to the registrar is 6 months from the close of the financial year, so typically September 30th.
Is there any flexibility on that 6-month deadline? It can be tight for a multinational.
There is. You can apply to the registrar for extension of up to 3 months if you have special reasons.
And we need to talk about jurisdiction again because it's different from the initial registration.
Yes, this is a key point to remember. The initial FC1 went to Gurgaon, but these annual financial documents get filed with the ROC in New Delhi.
That's a critical distinction. And Can a company get permission to use a different financial year, say, to align with its parent company in the U.S.?
Yes, but you need permission. The central government can approve a different financial year if it's necessary for global consolidation. So if RK Limited in India needs to align with its parent, HOK Limited in Japan, it can apply for that exception.
The balance sheet and P&L are the core, but what other key statements need to be annexed to them?
The annexures are all about tracking the flow of money and influence. You need a statement of related party transactions, a statement of repatriation of profits back to the parent, and a statement of transfer of funds.
So total transparency on financial movement.
Total transparency. Plus, you also have to attach the parent company's latest consolidated financial statements from its home country. This gives the Indian regulator the big picture.
And the list of all their business locations in India.
That's filed in Form FC3, which goes in along with all the financial statements. It keeps the regulator's map of their operations up to date.
All right, let's move from the financial paperwork to the more tangible day-to-day operational rules. Section 382 is about display. How does a foreign company have to present itself to the public?
The goal of Section 382 is to make sure there's no confusion about the company's foreign origin. At all of their offices and places of business, they have to conspicuously exhibit their company name and their country of incorporation.
And in what language?
Both. It has to be in English characters and in the characters of the local language of that area.
So in Chennai, it would be in English and Tamil.
Exactly. And the same information, name, and country has to be on all their official documents. Letterheads, bills, notices, everything.
And what if the company is a limited liability entity?
Then they have to explicitly state that fact. The words limited liability must be on all their documents in legible English, and also displayed at their offices in both English and the local language. It's about protecting creditors and customers.
Makes sense. Now, let's say I need to sue a foreign company. How do I serve them a legal notice? Section 383 covers this.
The process is made very simple. You just have to serve the notice on the authorized representative that they registered with the ROC.
And how can I deliver it?
You can leave it at the registered address, send it by post, or importantly, serve it via electronic mode. The law recognizes email as a valid form of service.
Okay, now Section 384 is a bit of a catch-all. It pulls in other important sections of the Companies Act. What are the big ones that get applied to foreign companies here?
There are a few really critical ones. First, the annual return. Just like an Indian company, they have to file an annual return using Form FC4 within 60 days of the end of the financial year.
So that's on top of the financial filing.
Yes. Second is books of account. They must keep their books of account for their Indian business at their place of business here in India.
What else?
Registration of charges. The rules in Chapter 6 for registering any loans or security against their assets apply fully. This protects lenders. And finally, corporate social responsibility.
So CSR applies to them too.
If their Indian operations meet the turnover, net worth, or profit thresholds under Section 135, then yes, they are subject to the same mandatory CSR spending rules as an Indian company.
That's a significant obligation. And Section 385 just clarifies they have to pay the standard fees for all these filings.
Correct. No filing is complete until the fee is paid.
Now let's shift gears completely. What if a foreign company wants to raise money from the Indian public? This brings us to the prospectus rules in Sections 387 to 389.
And this is where the rules get even stricter. The most important thing to understand here is that these prospectus rules apply even if the foreign company has no place of business in India.
So just the act of offering securities to the Indian public triggers this?
Yes. If a broad LTD in the UK wants to market its shares to Indian investors, the moment that prospectus enters India, these sections are triggered. Investor protection comes first.
So Section 387, what does the prospectus need to contain?
First, it has to be dated and signed. It must detail the company's entire legal history, its incorporation documents, the laws it was formed under, the date and country. And it has to give an address in India where all these documents can be inspected.
And does it also have to follow Indian disclosure standards?
It does. It has to include all the matters specified under Section 26, which is the main section for domestic prospectuses. So financial reports, management discussion, all of that. Indian investors get the same level of information.
What about if they include a statement from an expert in the prospectus, an engineer's report, for example?
That's covered by Section 388. The expert has to give their written consent to be included, and that consent must not have been withdrawn before the prospectus is registered. The prospectus has to state this clearly. It makes the expert accountable.
And the final step before they can distribute it is registration under Section 389.
Correct. A certified copy of the prospectus must be delivered to the registrar for registration before it can be circulated.
And who certifies it?
The chairperson of the company and any 2 directors. And the prospectus itself must say on its face that a copy has been delivered to the registrar. It's the final regulatory check.
And what documents have to be attached to that copy?
It's a long list. The expert's consent, if there is one, the MD's appointment contract, any other material contracts from the last 2 years that aren't in the ordinary course of business. The underwriting agreement, it gives the regulator a full picture of the company's commitments.
Okay, let's touch on 2 advanced concepts now. First, Indian Depository Receipts, or IDRs, under Section 390. What are they, in simple terms?
Think of IDRs as a way for Indian investors to buy shares in a foreign company, but in Indian rupees on an Indian stock exchange. A domestic depository in India creates these receipts, which are backed by the shares of the foreign company.
So it makes global investing easier for Indians.
Much easier. But because they're raising money from the Indian public, the regulations are tight. They have to comply with the Companies Act rules, the SEBI ICDR regulations, and RBI directions.
Right. And the second advanced topic is cross-border mergers under Section 234. Can an Indian company merge with a foreign one?
Yes, it can. Section 234 allows for this, but only with companies in jurisdictions that have been approved and notified by the central government in consultation with the RBI.
And it works both ways. A foreign company can merge into an Indian one, and vice versa.
Both ways are possible, which is a big deal for global M&A. But because you're moving assets across borders, RBI approval is absolutely mandatory.
Okay, we've covered the rules, now for the consequences. Section 392 lays out the punishment for not complying. How severe is it?
It's designed to hurt. The fine on the company itself is a minimum of 1 lakh rupees going up to 3 lakh. But the real penalty is for continuing default.
What does that mean?
For every single day the noncompliance continues, there's an additional fine of up to 50,000 rupees.
50,000 a day? That adds up incredibly fast.
It's meant to.
Yeah.
A month's delay could cost them 15 lakhs. And it's not just the company. The officers in default, the directors, the authorized representative, they face personal fines too.
How much for them?
A minimum of 25,000 rupees, which can go up to 5 lakh rupees. So there's serious personal financial risk for the people in charge.
Now, for the most legally interesting part, I think. Section 393. What happens to the contracts a non-compliant company signs? Are they void?
No, and this is a masterstroke of legal drafting. The company's failure to comply does not make the contract invalid. The contract is still perfectly legal and enforceable by the Indian party.
So the Indian company is always protected?
Always. They can still sue the foreign company on that contract.
But the non-compliant foreign company loses its rights.
That's the hammer. The non-compliant company cannot bring any suit or make any legal claim related to that contract. They are barred from the courthouse.
Until when?
Until they fix their compliance. The moment they file all the overdue documents and become compliant, their right to sue is restored.
Let's use an example. XYZ, a foreign company, sells machines to ABC, an Indian company. XYZ hasn't registered. ABC refuses to pay.
XYZ wants to sue for payment. But under Section 393, the court will refuse to hear their case. They are legally paralyzed until they get their registration in order. It forces them to comply to protect their own business interests.
It's a very clever enforcement mechanism. Are there any other liabilities to be aware of?
Yes. Section 391 makes it clear that the prospectus liability sections 34, 35, and 36, which cover civil and criminal liability for misstatements, apply fully to foreign companies. If they lie to Indian investors, their officers can face jail time.
So we've covered a huge amount of ground in this audio lecture, from definition all the way to penalties. The main theme seems to be accountability, whether the company is here physically or just digitally.
That's the essence of it. We've seen the 30-day clock for the initial FC1 registration in Gurgaon, the 6-month deadline for filing audited Indian accounts with the ROC in New Delhi, the 60-day window for the FC4 annual return. It's a cycle of continuous disclosure.
And that clever twist in Section 393, where non-compliance doesn't kill the contract but freezes the foreign company's ability to enforce it, really stands out as a powerful tool.
It does. And the detailed rules around electronic mode show that Indian law is keeping pace with the global digital economy. You can't extract value from India virtually and expect to escape legal accountability.
So to wrap this all up, let's leave our listeners with a final thought to chew on, something that connects a few of these complex ideas together.
Okay. We've talked about the high personal fines for officers under Section 392 for noncompliance. And we've talked about how Section 393 paralyzes the company's ability to sue.
Right.
But imagine a scenario. An officer of a noncompliant foreign company knowingly signs a contract to get funding from an Indian entity, but that contract contains false information. The Indian entity loses money.
Okay, so there's a loss based on a false statement.
Exactly. We know the officer already faces huge fines under Section 392 for the registration failure, but how might Section 36, which is the punishment for fraudulently inducing investment and can lead to imprisonment, compound their personal criminal liability?
So you're asking about the intersection of the administrative failure to register and the active criminal act of fraud.
Precisely. How do those two sections work together to create an even more severe outcome for that individual officer? It's not just about fines anymore. It's about potential jail time.
That's a fantastic question. It really forces you to synthesize different parts of the act. Understanding that connection is what separates a good student from a future professional.
It's the difference between knowing the rules and understanding the consequences.
A perfect place to end. Study smart, everyone, and we'll catch you on the next audio lecture into corporate law.
Don't forget to like and subscribe.